Hello, everyone. Uh, do we have our panelist, Mr. Sharma? Are you there? I can see a beautiful picture.
I'm there.
Yes. Yes, we can. We can see you. Yes. Good morning, Mr. Sharma.
Good morning.
Yeah, your video just disappeared.
You want me to start the video again?
Yeah. Please, if you can. Yes, we can see you now. All right. So I think let's start the webinar. This is 12:05 sharp. To respect everyone's time, and I see a good number of people joined in, and few are others still joining, but that's fine. Let's start. Hi, this is Sumit Pahwa. I'm the co-founder and CEO of Complinity. Complinity is India's leading compliance software, helping companies comply with the laws of the country. Complinity covers 2,000 laws and checklists of 25,000 compliances updated on a daily basis. And it's adding value to 1,000 plus companies all over India, spread across 50 plus industries. Over 10,000 users use Complinity today from organizations like Panasonic, Max Hospital, Jindal Steel, Amaron's Battery, Roy 5-star chain, Bikaner Wala, Pizza Hut, KFC, Taco Bell in India, Toyota, DCM Shriram, JP Group, British Council, and many more. Besides compliance, we also have 12 modules covering registration, contracts, litigation, assessment, insurance, audit, internal financial controls, enterprise risk management, and many more. So it's a governance, risk, and compliance technology company. And I'm the co-founder and CEO. But other than that, I'm also a company secretary and lawyer with 25 years of experience, and happy to be part of all the fellow professionals. Joining us today is the eminent speaker, Advocate Mr. M.M. Sharma. He's an advocate with Delhi High Court, heads the competition law and policy practice of Vaish Associates Advocates, which is a 53-year-old law firm having its office in Delhi, Mumbai, and Bangalore. Mr. Sharma has over 30 years of experience, including judicial experience as a judge advocate in the Indian Navy for over 10 years. He holds a postgraduate diploma in economics of competition law from King's College, London. He's also worked in Competition Commission of India as registrar during 2006 and 8 during its formative phase, and then in Jindal Steel and Power as head legal. Mr. Sharma is a prolific writer on competition issues in major newspapers, journals. Even he appears on some television news channels, etc., and has contributed in the amendment of the Competition Act 2002, also in the Amendment Act with his suggestions. So, welcome, Mr. Sharma. We're very happy to have you. And this is the second in series, by the way, for some of you who might have heard him earlier. We did a competition law webinar, I think, few months back, where Mr. Sharma was there. Today, the topic is Competition Amendment Act 2023. Basically, Competition Amendment Bill was passed in Lok Sabha on 29th March 23, and after getting cleared from Rajya Sabha on 3rd April, it received President's Assent on 11th of April. This is the first time amendments are being made to the Competition Act post the enforcement of the Act in 2009. Competition Act provides for faster timelines for approval. Amendment Act, I'm saying, faster timelines have been provided for M&A transactions. Certain incentives have been provided for ongoing cartel investigation. If someone discloses other cartels, they are given certain incentives or leniency. And law also has brought in the limitation period of filing complaints for anti-competitive agreements. Earlier, there was no limitation, but now a limitation of 3 years has been prescribed. And many more changes have occurred in the Competition Amendment Act. Now, why Competition Law or Competition Amendment Act is important to us? Because competition law is a very unique law, I would say. As Mr. Sharma very often puts it, it's an economic legislation or an economic law. It's not a pure, I would say, just a tick in the box compliance law. It is more to do with the business, more to do with how the organizations are conducting their business, how they are writing their agreements, what are the policies, are they anti-competitive? So the essence is, and the whole genesis of the competition law and the Competition Commission of India is to ensure a fair competition, to ensure that the anti-competitive behavior and anti-competitive agreements are not entered. The abuse of dominant position is not done by the large dominant players in any industry, and to ensure free play and a fair play for all the players in the market, all the stakeholders in the market for overall consumer benefit. So, and also, if some of you who follow competition law, you would have seen huge penalties being levied by Competition Commission of India, running into hundreds and thousands of crores on all the good brands that we use any which way. So it's difficult to imagine how would a Google or a Make My Trip or Oyo or other great reputed companies would run into these kind of issues with Competition Commission. So I think let's hear from the expert now, Mr. M.M. Sharma, to delve into two things. I think I'll initially I'll request him to cover a brief on the Competition Amendment Act. What are the key changes that have been brought under the Act? And then if there's any critical comment that Mr. Sharma would like to offer, being an expert in the law, his own views on whether the Act meets the needs of the shareholders or the needs of the industry or the regulator, or what are his views around it. So over to Mr. Sharma. Sir, if you could share your presentation and take the discussion forward. And as you're sharing the presentation, sir, you can share any audience, if you have any question, please put it in the Q&A box. You see a Q&A box on the right hand side. Please put your questions in the Q&A. We will take Q&A. There are, either in intervening or towards the end. We will see depending on the questions taken. So over to Mr. Sharma.
Thank you, Sumit ji, for this nice introduction, and I'm humbled by the introduction you gave about myself.
So, Mr. Sharma, yeah, one more thing which will, I think, help you, which I did last moment. There's a goal to understand the audience, and it'll be very interesting to know. If I may just take one more minute before you, I know, delve into the topic. If you could answer, please, in yes or no. Have you read or practiced or dealt with competition law? It'll give a good insight to Mr. Sharma as to how much technical he should go. Either read or practiced or dealt as an in-house counsel or a CFO or MD, CEO, director, whatever you are. It'll give a good flavor, Mr. Sharma, to you to see the mix of the audience. So we'll wait for 10 more seconds. All right. So, okay. Very quickly, last 10 seconds, if you could quickly answer a yes or a no. So I think as of now, Mr. Sharma, I see a 50-50 split broadly. 50% have read or practiced or dealt, and the other 50% have not. So I think the other 50% would love to know more about. Although the caveat is Mr. Sharma is quite technical, and he will go technical. So I think we all are looking to hear the technical expertise. So I think over to you, Mr. Sharma. I'll end the poll here and over to you.
Thank you very much. So there's no technicality. See, Competition Act, as you very rightly said, is not technical at all. It is more business friendly. It is for the businesses, how the businesses are conducted. And Competition Commission of India is actually a fair market regulator. To see that the markets behave in fair competition, and they eat the big, doesn't eat the small. That kind of a situation doesn't happen. The law of jungle doesn't come to the markets. So competition law, as you very rightly said, is an economic law. So this webinar today basically is about the amendment which have been brought into the Act. And this is the scheme of my presentation. I'll first take you through the background of the amendment, why the amendment was actually needed. And then I'll run into specific provisions which are important. Merger control, the enforcement provisions, and then certain new ideas have been introduced. And then the miscellaneous changes for the procedural aspects of the law. And then at the end, as you said, I will cover I'll give my own critical appraisal on the amendment, whether they fulfill the stakeholders' aspirations or not. So competition law, as you said initially, is basically a law which deals with the market. It is the law which every entrepreneur should know. Every businessman should know about the competition, and particularly the medium and small enterprises. The large companies have their legal departments. Everybody has their own, experts with them. But it is the small and micro and medium enterprises which should know this law very well, because they are often the victims of the ignorance of the law. Whether either they are changing information through WhatsApp and then they get caught in a cartel, or they are actually being arm twisted by the supplier by not supplying the goods and things like that, and supplying at a very high price, or there is a cartel of suppliers. That's also possible. So ignorance of this law actually means that your profits will go down. You will not be able to grow, and you will not be efficient enough. So basically, competition in the market ensure that you are efficient and you are always on your toes to do the best. That is very well known. So I don't have to repeat it. So why the amendment was needed in the whole place? So this law has been in place for 10 years. 2009, when the law was actually brought into force, 20th May 2009. And since then, the competition regulator has done a, I would say, fairly good job, because they have, they have actually handled about 1,000 plus cases of antitrust, of cases that they've handled, and about 1,000 mergers. They have actually about over 1,000, around 1,000 of mergers they have cleared. So they're actually their work has been has been quite appreciated all over the world. Competition Commission of India has actually entered into MOU also with the other countries' antitrust authorities, and I have attended a few of them. So they're very proficient and a very efficient regulator. There's no doubt about it. But why the law was actually needed to be amended? So I've just given you the bullet points here. So they were changing business landscape over the period of years. So it's the emergence of newer and disruptive models of business, particularly the digital markets as they emerge. New business models have emerged, and digital markets and e-commerce, for example, they are totally new. The traditional buyer and seller relationships are not there. The platforms are there who have both the buyers and sellers with them on both sides. There are network effects, and they create a different ecosystem which was not known earlier in the normal markets. An ecosystem in which there is a private competition, and then the problem comes when they start behaving, in a preferential manner to players with whom they have their own dealings, with whom they have their own stakes. So kind of competitive neutrality of the platform goes. So I've spoken a lot about it, so I'll not repeat it, but the digital market themselves and the way the e-commerce is conducted is a challenge. It was a challenge actually for the authority, even including the CCI. Then there were certain other requirements like codifying the legal principles. The jurisprudence evolved over a period of 10 years. So new concepts actually came to be noticed by the commission, like supply side substitutability and vertical agreement like hub and spoke cartels. I'll speak about that later when I touch the subject. Material influences control on the combination side. So these issues actually emerged because over a period of a year, the CI, as it passed orders, certain experiences were actually gathered. And they were required to be brought into the law, because otherwise, particularly the combination side, the competition commission was mostly, running the show through the regulations. So the regulations have actually not that force of law as an act itself. So they had to be brought into the act. That has been done now. And then the third was the need for bridging gaps in the enforcement of law. There are certain areas, there are certain gray areas which were noticed into the law by experts, which, such as, for example, penalty caps. How much penalty can be imposed by the CCI? Whether it should be total turnover or whatever, or etc. Gray areas were there. So gray areas, this is a highly legalistic subject, but suffice to say that there were certain procedural, lacuna, like one of the sections of the Competition Act, Section 26, that where the Competition Commission, for example, disagrees with the findings of the DG. Then can it pass an order closing the case? There was no such provision into the act, existing act. So they used to pass orders which were not available before the appellate tribunal. So there were areas which need to be stated. And then of course, the most important was the making the law business friendly. See, we are living in an age where our present government talks of ease of doing business. They never stop of talking about it. Ease of doing business is the mantra of the present government. So naturally, the CCI had to custom itself. So the more and more they make the laws, certain, transparent, and regulatory certainty is brought, particularly in the case of combinations, confidentiality is handled very carefully. So all those things had to be brought into the law. So that was being done by practice, but now it has been brought to the law. These 4 or 5 areas are the reasons why the act had to be amended, and that's what the amendment has taken place. Now, what actually happened, how this process happened, here's a slide. You can see that the government set up a review committee, the High Powered Competition Law Review Committee in October 18, which submitted its report in July 19, and it was placed before the Lok Sabha, and which now the Competition Amendment Bill was passed, was actually drafted in 2020, but which lapsed because of the COVID, etc. The Parliament never could convene because the COVID came. And then this was revived in 2022 as Amendment Bill of 2022, which I think Sumit has already mentioned that. And it was cleared by the Lok Sabha on 29th of March, after the PSC gave a recommendation in December 2024. So the current winters in the current monsoon session. It was sort of winter session was passed, and then finally it was passed with Rajya Sabha on 3rd April and received presentation, etc., etc. So basically, now the act has become force. Act has become come into the law is no question of any debate or anything. So the point is comments were given, but one thing I like to mention is this actually process of amendment actually went for 5 years. It is 2020, almost 4 years. You can say. So the comments were made by the stakeholders, by the various apex chambers of the such as SOCHM, PSD chamber, even CII. So they gave comments to the expert body. The 20 was referred to the Parliament Standing Committee. And the Parliament actually did a very wonderful job because in a period of months, it was referred to them in August 22, and in December they came out with a report, so-called 52nd report. A report actually basically formed. So this bill was actually had PSC recommendations, but I am sorry to say that some of the recommendations were actually not accepted by the government, by the parliament also. Some of the recommendations of the even the PSC have not been accepted, which will tell critical appraisal. So the specific of consultation has taken place. So this brings transparency into the stakeholders, and that is a good thing. Competition Commission of India at least can be commended. But this, this type of function, whether it is the regulations in the amendment bill or the leniency, whatever they come out, they have a fair amount of consultation with the stakeholders. I'll stop here if there is anything. Topic on merger and acquisition. If Sumit has anything to add or anything to ask me, I'm here.
Yeah, no, but before that, I'd like to ask the audience. I could see some breakage in the voice of Mr. Sharma in between. So, is everyone able to hear clearly, or are there any breakages? Could you put it in chat box if you, or give me a thumbs up if you are able to hear clearly, or a thumbs down or a chat box if you are experiencing certain issues. Can you please let us know? No, okay. The voice is breaking. Can't hear clearly. Yeah, there is a breakage. Okay, issues with breaking not clearly. So, Mr. Sharma, there looks like some bandwidth issue somewhere.
I think I'll shift to the physical. This thing. Give me a second.
Yeah.
Give me a second. I'll change the Bluetooth to the physical wire.
Please. Just bear with us for a.
Please let me know whether it is better or not.
Yeah. Right now, yeah, it looks good.
So I've shifted to the physical, it is called device. So I hope it will be better now.
Okay, okay. Yeah. This is better.
Thank you.
Okay, right.
Thanks for the feedback. Because this is the problem I'm facing. The voice actually sometimes over the Bluetooth doesn't come that good.
No, this is much clear voice, and I hope the internet also supports all of us. Okay, so friends, bear with us for a little bit of voice here and there, but I'm sure Sharmaji will get more deep dive. Right now, it was a high level background only, but yes, now the more deep dive will start. So Sharmaji, I don't think any questions.
So I'll begin my next topic.
Yeah. Please proceed to the next topic. So maybe now you could deep dive into the merger control, because I think there some good changes have happened on the merger side.
Yeah.
So
exactly.
competition merger. So so as competition law, everybody understands is divided into three sections. One is the combinations, mergers, etc. The other is the abuse of dominant position, and the third is anti-competitive agreements. And then of course there are other miscellaneous provisions, etc. So merger being one of the very important one which applies to corporates. So Mr. Sharma, what changes have been done in the combinations, mergers, procedurally, and otherwise in the thresholds, timeline, etc. It will be interesting to note that. Yeah.
Thank you. So let me start with this merger control provision. Let me first add a caveat here. Let us all remember that mergers and acquisitions are not prohibited, but only regulated under the law. Unlike the anti-competitive agreement, which are actually prohibited, whether this competitor agreement between the direct competitors or between vertical also, or the abuse of dominance. This mergers and is not prohibited. So why it is regulated even? Because there is a concept of single firm dominance. I'm just giving you a little bit of economics behind it so that people understand why do they regulate, because it was seen as a handicap for the businesses, because there was a long, I remember when I was in the seaside, there was a long protest, very strong protest even for the inclusion of this provision in the act. And why should you regulate merger and acquisitions? They are the business, how the business grow. Organic growth of business takes place through the merger and acquisitions. So why should CCI even enter in this space? The point is, the problem happens is that when there is a possibility of a single firm dominating the whole scene in the market, so that actually that's the requirement where the commission has to step in. And the theory of harm is known as unilateral effect. So you should not monopolize the market to raise prices above competitive levels. That is the basic fundamental principle. So if there is suppose Vodafone and Vodafone and Airtel, and now there is the third Geo. I'm just giving you an example. So there is a triopoly. So there's sufficient competition into the market. People have a choice. So people should have the choice always. That is the purpose of this act. And so mergers acquisition are regulated because CCI will always ensure that there is some competition in the market remains. So if there is suppose a direct merger between two cement companies in the same area, they will see that the divestment takes place. So the third party has to be brought in to buy. Divestment is also ordered. So this is the basically understanding of the subject. And then now let me come to this slide basically sums up. This slide sums up the existing law, that is merger, amalgamation, acquisition of shares, and there are high threshold limits. This is the existing law as I just summed up. And there's a mandatory regime. So there is a suspensory regime in India where you, after you file your till the CCI approves, you cannot take any step. You just cannot take any step. The whole thing comes to a standstill. It's called a standstill obligation. And then the commission was given 210 days to decide without, or this was deemed as approved. And or suo motu action can also be taken if you don't file the notice to the CCI in such cases. And this is an ex ante regulation. That is very important because why it is ex ante? Because if the merger has taken place and then you cannot unscramble the omelette as it is said. So basically, this is ex ante is the only provision in the act which is ex ante. Otherwise, the other provisions are all ex post. So after the effect has taken place, the CCI will intervene. In this case, they have to do an advance checkup. It's basically advance assessment of what will happen in the market if we allow this merger to take place. Not only merger, an acquisition. So if the large player acquires a small player, what will happen? The choice will go whether the consumer will be happy or not. And it's not only the consumer welfare standard. The competition per se should not be reduced. Please remember one thing, that the competition law, of course, the ultimate objective is of the consumer welfare, but consumer welfare, in my opinion, is not the only object. The total welfare is the object. That means welfare not only of the consumer, but also of the producer also. So both have to be equally happy. So with that thing in mind, these regulations have been made. Now I'll just come to the straight away to the changes which have happened. And these are the existing thresholds. You can see they are the highest in the world. 2,000 crore of assets and 5,600 crores of turnover for a single company, blah, blah. I'm not repeating. You can see there is a de minimis exemption that is extended till for 10 years to 27 March 2027. That means if the target size is smaller, 350 crore of assets, 1,000 crore of turnover need not file. So those exemptions have already been given to the industry by the government. But there is another interesting feature of this definition of the group, for which the extension was granted, but it actually has lapsed in 2021. It has not been extended. That's an important thing. That's why I've highlighted in yellow. So the definition of group earlier was in the act was 26%, but they extended to 50% voting rights. That will be covered as a group, but then it has not been extended for 21. But now it has been codified in the law and brought back as 26%. So now I'll deal with the specific changes which have happened. So a new threshold, you see, of deal value threshold has been introduced. Earlier, we had a 12 threshold of asset and turnover. So either you have assets of 2,000 crores or you have turnover of 2,000 crores. So now what they have done, a deal value threshold. That means what is the size of your transaction, how much business you are taking over. So this threshold also has been kept synonymous with the asset based, that is 2,000 crores. So it is not arbitrarily, this figure has not been arbitrarily picked up according to me. It has some semblance of a reason, because the minimum criteria for combination was 2,000 crore of assets. So now they say if you have a deal which exceeds only 2,000 crore, then only you need to be considered as a combination. And but there is a proviso here. The proviso is a substantial business operation. That means you should have local nexus in India. So if Google is acquiring some company, right, the deal size is just 500 crore, it need not notify. Google may have whatever turnover. Simple example. But if the deal size is more than 2,000 crore, because that will be written in the subscription agreement, etc. So then it has to notify, provided it should be presence in India. So the local nexus is an additional threshold, additional caveat provided that was very well thought of and very well discussed in the competition law review committee. And this substantial business operation, what it will be actually be notified by the government by rules. No, sorry, by the regulation by the CCI under section 64 of the Act. So substantial business operation in India will be for which regulations will come, but I can tell you that it is something to do with local nexus, how much presence you have. And this is just imagination, whether it is e-commerce, how much they'll take up. So it depends, but this notification has to come. Now, the second thing is definition of control. This is equally important, the dilution of center of control from decisive influence to material influence. Now, what does it mean? See, the ability of control, if you see the definition of what is a combination, it is the ability, a combination takes place when you either acquire voting rights, assets, shares, or control. So all others are specific figures, how much shares you've acquired, how much assets you've acquired, they're all quantifiable. But the control is something which is not quantifiable. So control has the most controversial, subject in the competition law for this topic is control. What is a control? So control can have, whether you are in a control, whether you actually acquire more than 50%, then apparently yes, shares, that there is no problem. But what if their control is only minority? Suppose you acquire only 25% of a company, or only 20% of a company, or even my minority shareholding. You have 10% of minority shareholding. Still, will you be considered as having a control? Will you be considered as acquiring a control? Now, what the CCI earlier was, the view of CCI earlier was that initially they were going by decisive influence. Only if you are acquiring what is known as a uh, a position in which you can decide.
I think some internet connection issue again at Mr. Sharma's end. Let's hold for some.
Connected.
Yeah.
Am I audible?
Mr. Sharma, you were disconnected in between, so maybe
again?
Definition of control you can again start with. Yeah.
Am I back again?
Yeah, you are back again.
Okay, good.
So dilution of definition of control, maybe you were speaking, so you can start with that.
So this actually codifies, this amendment actually codifies the existing decisional practice of which has evolved over a period of 11 years of the regulation of companies. So initially it was decisive influence, then it was slowly changed to material influence. And this actually, material influence has also been debated. What is material influence? So do you mean that if I appoint a board of director in a company I'm acquiring, or I'm an investment advisor, I'm a PE fund, for example, I appoint an observer into a company just to observe will it be considered as material influence? Yes or no? It's gray area. You don't know. So this is actually, according to me, a very debatable, still not a very progressive step. Rather, it's a step backward. That's why if anybody happened to see my blog, which I wrote recently in my blog, the India meant the competition law, this I took it as a retrogative step, according to me, that it's a very vague test because substantive, it will lead to substantive gun jumping. I'm a venture, I'm a private equity investor. I'm a PE investor, and I keep on taking shares in the companies. But will it mean that if I put an observer or anything which I do, which has a presence in the board, which will be considered as a as kind of as control or material influence? So material influence actually is a vague test, but the government, for whatever reasons, because there was a debate in the CLRC which said that material influence and disinfluence you have to decide. But ultimately, I think the standing committee also went in favor of the material influence test. So this will actually lead, according to me, cases of gun jumping. Gun jumping means that you violate the law not by choice, but by ignorance of law. It negates earlier jurisprudence where mere acquisition of affirmative was not considered as equal to acquisition of a control. and list of such right leading to joint control or strategic commercial operations were provided. So basically, when the control shift from sole control to a joint control, that is the point. That's where the material influence actually is tested. So according to me, CCI can, can do anything. I mean, in this case, it's a very, very vague test, which actually needs to be little debated. Then of course, turnover and value of transaction have been defined for this. Now I come to the other changes, the removal of mandatory 30 days limit. Now these are the changes which one must note. So there was a 30 days trigger initially in the law, which was that you have to notify the transaction within 30 days if it's a combination. That means if your transaction is meeting the thresholds, if your total both parties assets and turnover are exceeding the limit which are given into the section 5, if it is a combination, then you have to notify that combination within 30 days of the signing of a binding document or any other document which was defined. Now this has been removed. Actually, it was removed much earlier in 2017 by notification, but now it has been codified. It's not that it has been done now. It was already there. It was already been done, but now it has been practiced. It has been brought into the law, so it has been formally codified. 30 days limit has been removed. And then the important thing is other documents have been actually explained. That is voting rights and including hostile takeovers or making public offer also as per the SEBI regulations. So this option, this is a very important change of open offer. If you make an open offer, and if you do notify to the other regulator, and if you don't notify to the commission, there were cases where they were considered as a gun jumping cases. Penalties were imposed because public offer was made and the SEBI was informed under takeover code, but CCI was not informed. They were informed after the SEBI had been informed. So the commission considered them as a kind of a negative, as a kind of a gun jumping, and penalties were imposed. So this has been actually thankfully removed. So this now this is the biggest change which has happened. So waiver of obligation of, I think this comes here. This comes in the next slide. I'm sorry. Waiver of standstill obligation for open market purchases. So existing standstill obligation in case of open offer and acquisition of convertible shared securities is waived or provided, and notice for such acquisition is filed within the statutory time limit to specified by the regulation. So this is the caveat they have put. So it's not that they have totally done away with it. They are going to come out with regulation which will specify the time limit within which you have to with which you have to give the notice to the CCI. And also within that period, why the CCI has approved, the acquirer should not exercise any ownership or beneficial rights or interest into such transaction. They should not do it. So the new section 6A has been inserted now under the Act.
Mr. Sharma, for certain non-technical folks, including me, if you could clarify what is standstill obligations and slightly make it easier to understand.
No, as I said in the beginning, standstill means that when there is a combination, if a transaction qualifies as a combination, that means you have thresholds meeting, right? So you cannot consume that transaction. You cannot proceed with the transaction. You have to get it cleared with the CCI.
Right.
Until the CCI clears it, your transaction will remain suspended. It's a mandatory suspension regime, we call it. That is standstill obligation. And if you don't
seeking the approval and you cannot go ahead without the approval, that's what you're calling a standstill.
Exactly. And see, there are big ticket size, big budget, big size. You can understand 6,000 crore plus, 2,000 crore plus. We are talking, and they are big companies, and they are they purchase the joint, and including the joint venture also, for example, they also have to be notified. So these big ticket transactions, they require prior approval because, as I said, they affect competition.
Yeah.
And their appreciable adverse when competition is possible.
On the earlier slide also, I was noticing when the 30 days time limit to report this thing merger has been done away with. So earlier the board of directors used to file a resolution or any other document was to sign, and within 30 days one had to approach CCI for approvals. But now that
if you don't, you were penalized. There were I think various cases where they were penalized. The huge penalties were issued.
Right. So now that 30 days has been removed and it says before consummation of your merger or other combination, you need to approach CCI, and CCI will then revert within 150 days as opposed to earlier 210 days. So
no, 150 days is the maximum time with which They have to approve it. Otherwise, it will be deemed to be approved.
Otherwise, it will be deemed to be approved. Earlier, that limit was 210 days, right?
10 days. Now the limit has been reduced to 150 days.
So, what is the reason for removal of this 30-day reporting? I mean, now after board resolution, I can even approach after 3 months, 4 months. So, what is the reason for removing 30-day timeline?
See, this is just, as I said, to give ease to the business, to the industry, just to give ease of doing business. The concept is making it business friendly. Those unnecessary penalties were imposed on large companies, including Tata. Big companies were penalized for 1%. Imagine 1% of turnover. It's a huge penalty.
Right, right.
So why should they? Because this is a technical requirement. Because you will, in any case, take 210 days.
Yeah.
Why you insist on 30 days filing when you're yourself going to take 210 days? So let me file after, say, 35th day. What is the problem? Heaven is not going to fall. So the industry actually lobbied with the government, the Ministry of Corporate Affairs, and that's why this change was brought in 2017. As I said, it's not a new change.
Yeah, but it's been codified now. Right.
Now it has been codified. That is what is very important. So, and similarly, the open market purchase also. You see, there were cases of, there were various Ultra Tech Limited, some various cases. I don't have to give the case of where the even GE Alstom, where the open offer was made, public announcements were made, but CCI was not informed. So just because it was not done, the penalty were imposed.
Right.
So these cases went up to the Supreme Court. It was actually unnecessary litigation, which has now been removed, thankfully. And this open market purchase is a very good, system, though they have kept the control over them by providing regular time within which they have to inform the commission.
For open market purchase, what is the time limit now?
No, they will come out with regulation, I said.
Achha.
Written, they have to come out with regulation and prescribe the statutory time limits.
Okay.
But within that period, they don't have to exercise any control. So I'll give you an example. There was an example of a company I will not name, which gave a loan to a company which was dying. It's almost, and they wanted to acquire that company. I mean, I will not name because it's very well known. And this some few crores, hundreds of crores loan was given so that their store can run. Now, because they gave the loan to make the company viable, CCI considered it as a, and then they filed a notice in the CCI that we are taking over this company. Pinani, I don't have to name. So what happened was the CCI started 43A proceedings against the company, large company. And why have you given loan? Though in the investment agreement was very clearly written that this is a refundable loan subject to the approval of CCI. Even then, the CCI considered as a gun jumping. So I'm saying there were very controversial decisions. This time is not permitted me. I'm not going to go to those individual cases, but this was a very, very big handicap for the industry. They were very, very troubled. What is this happening? No reason, no. Because law was like this. So the CCI had to follow it. But now, thankfully, the government has changed it. And that's why this has been made more business friendly. And then important thing, green channel. Let me proceed to this. What is the green channel case? That you people already know. So green channel actually is was also started after 2018, immediately in 2019 by regulations. CCI came out with a regulation that where there is no horizontal overlap, there's no vertical overlap, and there's no complementarity also between the two parties. Then they need not wait, and it is deemed to be automatically approved after filing. They have to file. Filing has to be done. If there is a transition between two large companies, which has no overlap, understand? But still you have to file it. But you don't have to wait for the CCI's approval. This was deemed to be automatically approved. So this was going on. Many filings have been done by the CCI. In fact, many green channel have been filed, hundreds of them. But now it has been codified properly by adding section 6.4. A new section has been added.
So these rules would be yet to come, right? For green channel and other things.
No, there's no rule requirement now. Now the law is there. Yeah, the rules have to prescribe criteria, as I said, already known to the industry, but they'll come up with formal rules. The rules are, as I said, no horizontal overlap, no vertical overlap, and no compatibility. Well, where there's no question of any competition issue coming at all,
okay,
then why should it wait? It should be deemed to be approved. And then, of course, this section has been added. The next slide, as I said, yeah. Now, but there is some caveats are also there. So the penalties have been increased for, if you see, making false or incomplete disclosure in statutory notices to filed by the CCI. It has now been made 5 crores. While they have given benefit to on one side, the other side they have increased the penalty. And specific penalty for gun jumping also has been up to maximum 1% of turnover has been made, which is higher. for failure to give notice even under 6.2 or 6.4. I think with this, I stopped the discussion on the combination side. I mean, if you have anything to say, I
Right.
can take up. Otherwise, I'll proceed.
Let us see if there are any questions. Okay, so one compliment, Mr. Sharma said, excellent session by Advocate Sharma and good moderation by Sumit ji. So thank you, Mr. Ivan, for this thing. Mamta is asking, what is gun jumping? Yeah, it is used by you quite a few times. I think what you're saying, ignorantly stepping on the law is gun jumping. Is that right, Mr.
Exactly. Exactly. Gun jumping is where you consume the transaction without taking approval of the Competition Commission. Without the regulators' approval, you proceed with the transaction and inform the authorities, or you say proceed to ROC or wherever, and you start, exchanging business dealing. You have to be at arm's length till the approval of the CCI is given. So that is what is standstill obligation. This gun jumping is when you violate the mandatory suspensory regime or violate this standstill obligation which is created by the law. That is what gun jumping is. And gun jumping is of two types: substantive gun jumping and procedural gun jumping. So what they've removed is a procedural gun jumping, which was for 30 days, that you will file within 30 days. But still cases of substantive gun jumping will remain. Because, for example, if you consume the transaction without even informing the CCI at all, without waiting for CCI approval, like I tell you, you go ahead with the public offer, then it will still be gun jumping. And that's why I said material influence will come. People may not be knowing what is material influence. They may say we have not control. There are a number of venture capitalists going on in the market. There are a number of private equity fund in the market. Indian market is booming. And when Indian market is booming, people are coming to the Indian markets quite in large number. So they may like to invest in companies which are profitable companies. So every such investor which is making an investment has to go for the CCI approval. Because as the law says, there is investment made solely for investment purposes is not covered under combination. The regulation says so. But will it be considered solely as investment or not? That will be the question. Because there are separate schedules made under the regulations which explain these terms, which shortage of time I'm not able to explain. But the point is, there will be gray areas which will be there. So gun jumping will continue. It's not that gun jumping will go with these amendments. Only procedural gun jumping, luckily, has been removed.
Maybe you can unshare your screen for some time, Mr. Sharma, so that we can see you in a bigger screen. And just unshare your screen once if you can. There are a couple of more questions which I will ask. Yes, we can see you better now. Also, Ashish asked, what is the meaning of deal value? What is included in the deal value, basically?
Let me see the section as it is. I think it's better if I see the section, what it says.
Okay.
So the value of transaction, as I read, I'll just read includes every valuable consideration, whether direct or indirect, or deferred for any acquisition, merger, or amalgamation. So it's a very broad definition. So it is not only direct, value, even indirect value or deferred value. You may have seen certain future scope, into the market, into the growth of this business. Even that may be considered as a deal value. So it's basically to capture the e-commerce. Let me tell you, it's this deal value threshold has come to capture the big ticket size, big transaction between the digital companies with the large big tech companies. Because see, Google, for example, when Facebook took over WhatsApp, imagine the size of the deal. Imagine the size, $19 billion at that time. And it was naturally, but Facebook had no assets or turnover in India. So they never notified India. Though they notified in US, they notified everywhere else where deal value threshold exists. That is the catch. So now with this deal value, because now at least this third limb was missing. Basically, the third limb of deal value was missing in our regulation. We only had asset or turnover based criteria. So these large companies, they don't have, they transfer their asset they hardly have. What asset they have? And the turnover they transfer to their parent companies. They don't have any turnover in India. That is why the government is trying to regulate these big ticket companies so that the India's wealth doesn't go abroad. The idea is it's more like a Swadeshi kind of movement, I see.
So, Mr. Sharma, a couple of related questions from my side, just to sort of get home the point thoroughly. This is very important for combinations. So, if a company in the US, an investor in the US is acquiring a company, the holding company in Singapore by acquisition of shares, but the substantial value rests in India. just like the historical Vodafone case, and so many other things happen. So still
Yeah.
in this kind of combination where US acquiring a Singapore entity, but the value rests in India, will CCI not be required by anybody?
Yes, it will be because local nexus test. As I say, if you are present in India, if your presence is in India, though the transaction is taking place outside India, it will have effect on Indian business also.
Right.
You'll have to require, provided it is not de minimis, provided it is not a small target which you are acquiring. See, what happens, Sumit, is these are very smart. Companies are very smart. They do small business they take over. They small pocket they will take over, not the whole thing. Because now under the law, you can take over units also. So that's what people like us come into the advice. That's why we advise people, our client like this also. So they take small, pockets, small units of the industry. I'll give you an example. There are brownfield investments. Forget greenfield investments. So suppose a hospital chain in US acquires something in Max Hospital. It not acquire the Max Hospital complete. It acquires, say, a cancer unit of Max Hospital. And its total value will not be more than 300 crore. So you don't have to notify. So when you acquire units of running businesses, if those units, assets, or value are not above the threshold, you don't have to acquire. You don't have to go to CCI. That's how the business takes place. I mean, I don't have to explore everything to here. The point is, the companies are very smart. The corporate restructuring is done very smartly. That's why
Right.
law firms like exist, like us exist, and like you exist maybe. So that
Yeah.
is.
And incidentally, Max Hospital is using Complinity. Very
Oh,
quick.
that's good.
I
Great,
dare say
great.
anything more. I dare say anything more on that. Okay.
So I'm
Okay,
saying that we have client confidentiality, client
of course.
privileges with us. That's the point. Is that your question is very valid. So it's not that if there is a transaction. And one more thing, let me tell you, there is another question. Since it's a supplementary question, I must clear that if suppose there is a deal taking place outside India,
Right.
there are multinational companies which are present outside India. So they have actually filed their notice in their parent jurisdictions with their antitrust authorities. So will they now feel that since we have filed there, will they not file in India? They'll have to file. Now, even if they have filed, will they have to wait for the approval of the Indian authority just because the approval they have taken in US, for example? Suppose in their parent jurisdictions, wherever they are based, the authority, competition authority, they have cleared that merger, right? But in India, they have just filed. So should they wait for that, or should they go ahead with the merging the entities? They cannot. That will also be substantial gun jumping. They have to wait for the Indian legs approval.
Right.
Multinational companies which are present all over the globe, large conglomerates, they have to file in every jurisdiction they have to file. And they have to
Understood.
wait for the approval of the particular jurisdiction. Without that, cannot. There have been cases in this country where this has happened earlier. People did not know. There are large US companies who have paid crores of fines to CCI.
Right. And also, this 2,000 crore of deal value or 2,000 crore of asset value, in the same example, if the US company is acquiring a Singapore headquartered company, but the value is in India. So this 2,000 crore, is it the deal value attributable to the Indian business? Or if suppose Singapore has other subsidiaries in Philippines, Thailand, Dubai, etc., and if it's a global company, but okay with 60-70% business in India, so is it 2,000 crore has to be attributable to the Indian value or the overall deal value? So it's slightly confusing.
Very good. Very good question. Very good question. See, what the law says now is that the deal value should be about 2,000 crores. Now, deal value is wherever the agreement is taking place. You will have an agreement. There, the deal value will have to be mentioned that what is the consideration, isn't it? So the consideration could be anywhere. So in your example, if US company buys a Singapore headquartered company, and the value of the deal between them is 2,000 crore between the US and Singapore,
Right.
so that value has nothing to do with the presence in India.
Right.
In India, they had to just be present. They should have significant business nexus in India. That significant business nexus will be notified by the CCI by regulation. We don't know as of today. But they have to be present in India. And if they are present in India, irrespective of what value it is attributable to Indian company, this will have to be notified.
Oh, that's quite means just a
Just because they are present. Just because they are
isn't-
present in India. Just because they are present in India. So your
right.
presence in India, there are companies which are multinational, as I said, they have to notify to the commission. So the deal value will be between the parties, not whether they are present in India or not.
Understand. So this
So whether it is attributable to India or not, sorry.
the significant business nexus is yet to be sort of clarified or notified through
It is
regulation.
not you, it is yet to be notified by the regulation. We are waiting for this. Just the act has come.
Understand.
Just the act has come.
This is a new term which has come in the Amendment Act. Significant business
Yes,
nexus.
yes, yes. Earlier it was known as local access in the regulations. Now, this term has been coined by the Competition Law Review Committee and picked up by the Parliamentary Standing Committee. The
Okay.
Parliamentary Standing Committee has given this term, headed by Mr. Jen Sinha. So this is an interesting thing. This is a good thing, because why should we bother companies which are not present in India at all?
Understand.
Right. So, for example, Tata buys a coffee shop in Brazil. So Tata is not present. Suppose, for example, this company is not present, and that coffee shop has no presence in India. So de
Right.
minimis ho gaya na. That is why it is that is what is they need not file. So there is no presence of the target in India.
Right. Okay, and somebody
Can we
else.
proceed, sir?
Yeah, I think we'll take one or two question and then we can proceed to the next section. One
But
says,
you will have. I thought you will have Q&A at the end, but anyway, I don't mind.
no, no, I
It's
think,
as interactive as it goes. I like that. It should be the kind of.
ultimately, this webinar is all about creating genuine value for all of us. Everyone is a professional as well as a student, including me. And
I hope I'm able to create some value, something.
yeah, no, I'm learning a lot and I'm making my own notes also. So one more question, Mr. Sharma, which has come is, please explain what would be the effect of change in the definition of group post this amendment, that is reduction from 50 to 26% in group level notification. So what is the effect of this change from 50 to 26?
Sir, it's a big change. It's a big change, because after 2021, the group was broadened to include up to 50%. That means if you are having shareholder in a company and your shareholder in another company is up to 50%, that company will be part of the group. But now it has been brought to 26%. So it is actually halved. So it will widen the net. It will widen the net. More and more transaction will come into the CCA net now. Earlier they were exempted. Because people generally buy small percentages in companies. They don't buy 50%.
Right.
So they were actually earlier their exemption was you could buy up to 50% and you will not be required to. You will not be qualified as a group. So there are regulation on how intra-group and inter-group merger take place. That is a matter of detail. But the point is that exemption was actually enjoyed by the companies for 5 years. Good 5 years. But that has been withdrawn now.
So now with this, that means if anyone is buying more than 26%, these things will get triggered. If it is less than 26%, these things will not get triggered.
Not things, it will be part of the group. Not all things, it's a part of the group. It's a group transaction. Yeah.
Right. No, but that
so many caveats.
So CCI nods which are required, do they have anything to do with this 26 and 50?
No. It's your structure, that's all.
Okay.
It's your structure.
Okay.
If you are taking the benefit of being a group, suppose an intra-group exemptions are there, na?
Right.
Under Schedule 1, there are various exemptions given to intra-group mergers, intra-group transactions. So those benefits will go, basically.
Understand. All right, Mr. Sharma. So I think we can proceed to the next section, which is on
sharing the screen now.
Enforcement provisions you wanted to touch upon, right?
Yeah. That's.
Yes, please proceed.
So now let us come to the enforcement provisions.
Friends, you can keep posting the questions in Q&A. We will keep taking it after end of section or towards the end of the webinar as well.
So now this is the first change which has taken place. It's very important is on the cartels. Horizontal anti-competitive agreement. They have widened the net to include facilitators or hubs other than direct competitors in cartels and anti-competitive agreement, even non-participants. So what is a cartel? Basically, I hope most of the participants here who joined understand. So as a direct competitor, you're not supposed to be talking to each other on business term. You're not supposed to be talking about the prices which you're going to give to the customer, your capacities, your future business plans, things like that. You should not exchange information with them. No, there should be a degree of uncertainty into the market. That is what competition is all about. So if I know what my other lawyer colleague is charging a client, then I will be tempted to fix that price. I'll say I'll give you thoda kam de dunga main aapko, then I'll take the client away. So that thing never happens, because if that happens, that you're destroying competition. So in the competition, the choice should be with the client or with the customer, not with the supplier. That's what a competition basic fundamental is. But with the cartels, what happens is that the prices are fixed. Not only prices are fixed, the quantities are also, sometimes fixed, that we'll give this much to, and the markets are divided, like we have saw the cement cartel. So those actually issues have now been broadened. Earlier it was directly between the competitors. 3.3 wanted to say that the agreement should be between the direct competitor, then only it will be a cartel or an anti-competitor. But now what has happened is, it is including facilitators. You are not a in the same line of business, right? I'll give an example of a trade association. Now, trade association need to be very careful. Now, trade association is a body of those people who are competitors. But trade association itself is not a body. It itself is not in the same business, right? But could it be considered as a facilitator? So that is the moot question. When it will be considered as a facilitator, that has been provided now. Earlier there was ambiguity on this. So CCI, for example, just give example, not that I'm saying that every trade association is bad. It was being considered a plus factor. So if you are meeting in trade associations, and if you are competitive, suppose you are steel makers, suppose you are plastic manufacturers, suppose you are a printer, for example, and you are meeting in trade association. So that meeting itself was considered in some cases as a plus factor for a cartel, that you are actually colluding, you are having connivance with each other, because it is a platform you are getting where you can meet. Otherwise, if you meet otherwise, then of course there's a direct evidence. If competitors meet in a hotel before says putting the bids, it is obviously direct evidence, because it will at least show that there was a meeting of mind. But if suppose a meet at a trade association, then will it be considered as a plus factor or not? So now what the government has done is, please read the second bullet, facilitator of cartel to be presumed to be part of cartel, even though not engaged in similar identical trade, provided the intention to participate in such agreement is apparent, or if they are found participating. What it means is that you have to show intention. You get my point? So that, and now in this same context, I'll explain you now this element of mens rea which has been brought in. Some of my friends who are lawyers here in this audience today would understand what mens rea is. Knowledge and intention. Total mens rea has not been brought in. Only intention has been brought in. So element of mens rea has been included to safeguard alleged facilitator include trade association. Now why it has been brought in is because it will also capture algorithmic driven collusions. There have been cases in the Western world where AIs have been found to be facilitating collusion on prices at least, right? So this AI-driven collusions will be now captured by this provision, because facilitators will be caught only when they are. And I'll give you example of what is a hub and spoke cartel, since I said I'll be dealing with now. So indirect information exchange through a third party can amount to a anti-competitive agreement, provided there is a intention of that facility of that third party to do so. I'll give you the example. There's a supplier B and there is a retailer A and there is a retailer C. So A supplies to B some material and B supplies to C. Both are distributors of B. So B is the manufacturer, A and C are its distributors. So the rate what A gives, if that rate is known to supplier, and if the supplier passes that rate to C with the intention that the rate will be maintained by C, then it is a cartel. Then the supplier is acting as a hub and A and C are spokes. I hope I'm clear. So that is known as resale price maintenance. What will happen is that if you want your price to be maintained by all your retailers, you are a manufacturer, then you are actually facilitating a cartel-like coordination. Then it is illegal. Resale price maintenance is bad, is prohibited by law. So then the manufacturer or the supplier will act as a hub and the spokes will be. The best example is of the car dealers. The Hyundai case, the case of Maruti is also gone. Penalties have been imposed on them. They are in appeals now. Hyundai, of course, won the appeal on some technical ground, but the point is that that's what they were doing. The discounts were being fixed. They were actually appointing mystery shoppers. And the dealer, they used to go to how much discount these dealers given. And if the dealers were given discount more than what was prescribed by internal policies of the companies, they were actually given notices. And even there were cases of dealership being terminated. So there are cases of, in the auto sector, there are plenty of cases where this kind of arrangements have been found by the CCI. But the relief which the law has given is, it will be only when the intention can be proved by evidence. Now I go to the next. I hope this is clear. Now the change in the vertical agreement also. So this has also is very interesting. So it has widened the net to include agreement other than vertical agreements between manufacturers and dealers. So all other agreement, including but not restrictive agreement between manufacturer and dealers covered if they cause appreciable adverse effect on competition. Earlier, the position was that 5 categories of such vertical agreement were specifically named: tie-in sale, exclusive dealing arrangement, exclusive supply arrangement, resale price maintenance. Those are named into the section itself. But what the Act has done now is it has included all kind of business agreement which are not included in those categories. So, for example, there could be agreement between companies which are nor in vertical relationship at all, neither direct but nor horizontal, not vertical. So, I'm a manufacturer and he's not my dealer, but still I can have an agreement with a company which could be anti-competitive. So, those kind of agreements were going scot-free. I give you the example of Hiranandani case. So, Hiranandani Hospital, had an agreement with stem cell, kind of the company which was storing the stem cells of newborn, babies, this thing which stems are, the cord is removed. So they insisted that if you go to a particular stem cell, storer, then only you will be given the facility of prenatal facilities. So this lady says, how can you insist me? I can go to anybody. They said, no, we have an agreement with them. So this agreement was actually neither horizontal nor vertical. The business are different. Hiranandani Hospital was in a different business. This stem cell storer is totally different. So it is neither horizontal nor vertical, but still they had it. So they were actually caught. So these kind of cases will not be covered under this particular arrangement. And another categories of cases which are more particularly will be covered was, as I've said, more MFN clauses, the most favored nation clauses, non-compete clauses, parity clauses between the online trade agents, and you have examples of make my trip, Oyo cases, etc. That we can discuss if anybody wants to know. But those kind of cases will be covered. And then tie-in arrangement actually also been clarified. Service should be distinct product services, and even resale plus maintenance has been broadened to include any direct or indirect restriction on resale to dealers, not confined to price discount alone. So this is important. So resale price maintenance need not only be discount monitoring; it could be anything. It could be non-price also. So if you put a condition on your dealer or distributor that you cannot, you have to make a particular quality, for example, or delivery, etc., or you cannot areas of distribution are sort of fixed without that, or you even stop passive selling, etc. So those kind of issues will also not be covered under RPM. So basically, RPM has been broadened. So let me just share here. RPM is a practice which is very prevalent. People do it unknowingly. I'm sorry to say we have got many cases, many queries come to us, and we have been telling companies that please be careful. RPM it actually is prohibited under the European jurisdiction. In the mature jurisdiction, RPM is per se illegal. Because if you are a manufacturer, after you sell your product, whatever price you sell, and there is a P2P transaction between your distributor, thereafter what the price at which he sells or resales and where he gives into the market is his baby. You're not supposed to control that price. You are out of the picture once you manufacture and sell to the next in line. But if you try to maintain the price line or whatever, for whatever reason, it may come under RPM. I'm not saying it always comes. So that is the issue which I thought I'll just flag here. And then another issue is agreement between end consumers. So this will actually avoid unnecessary complaint by home buyers. In the case of real estate, actually it's to give relief to real estate sector, because after the DLF case of 2011, at least hundreds of complaints were received by the CCI against builders. And now who were the complainant? Complainant were the consumers. The complainant were the buyers of those flats or allottees. So there was no direct relation of the, either horizontal agreement or vertical agreement. They were saying that we are, but they were not covered under Section 4 because they were not dominant. So Section 4, DLF was covered because DLF was held to be dominant in Gurgaon at that point of time. So that is why Section 4 will definitely cover unfair pricing or whatever, or discriminatory things, etc. But Section 3(4) is very specific. So now it has been clarified, the law has been codified that they and consumer will be excluded from 3 sections of Section 4. And there were cases, interesting cases, like Jyoti Sarup Arora, I was a party to that case. And so they basically, everybody was, booked in under 3(4), that it is not it may be a case of, vertical agreement, may even be a case of cartel, because all of your, buyer agreement are similar. So even we had seen those cases in good old days in 2012-13. And now I proceed to the procedural aspect. So this inquiry, how to inquire into anti-competitive agreement, there have been changes in that also. So introduction of a limitation for filing information or reference to CCI has been introduced. That means time limit of 3 years has been given. It is not that you can come after 5 year, 10 year, anytime you want and go to CCI and knock at the door of CCI that there is anti-competitive agreement. I've noticed there is a conduct which is anti-competitive, but there is a time limit has been prescribed now, 3 years, and it is in sync with the law of limitation. It has been proviso has been added in 19.1, and actually it will to some extent it will avoid filing delayed or vexatious complaints. There's no doubt about this. And then the factors of appreciable adverse effect on competition have been fine-tuned in the clause C and D of section 19.3. I don't think I need to discuss them. You can read in the act what the factors have been given. And 2 new factors have been added for determining relevant geographic markets, characteristic of goods or services, and switching cost. And similarly, 2 new factors have been added for determining what is relevant product market, switching costs, and categories of customers. Again, they are highly legalistic provisions. I mean, only the lawyers will be interested. And then similarly, this streamlining the procedure for inquiry under section 19, that is under section 26. So under 26, the principle of res judicata has been actually brought in by backdoor. That means no inquiry into repeated, allegation will take place. So this new concept of res judicata, no repeat inquiry in cases which have already been decided. So we had one interesting case I'll just like to share of a Hyundai dealer who came from Punjab, who came after the case of Hyundai was under investigation and order was issued. So he had the similar problems of mystery shopping, and his dealership was also being terminated. We went and filed a complaint in the CCI. The CCI, they said that you have merits, but will not entertain because we have already decided a case against Hyundai and penalties have been imposed on Hyundai on the same ground. So they closed our case. At that time, we had no recourse because they closed under a gray area because they didn't go even to the DG. It was the case of 26.2. And the complainant didn't want to go to appeal, although the appeal was provided under 26.2 cases. So now what has happened is they have provided
Mr. Sharma, if I may interject here.
Yeah.
As a moderator, I think, unlike the audience, as a moderator, I have some right to interject as well. So, and thank you for
absolutely.
If in this Hyundai case, as a matter of curiosity, so since they decided against the principles and they levied some penalty, but if similar practice was again shown, there was another aggrieved party with similar practice, then why wouldn't the penalty be levied again? Why should res judicata be applied?
That is the point. That's what my critical appraisal will cover. I'm against this kind of principle.
Right.
We actually were very unhappy. We were very unhappy with this.
Right.
So why should you? That means that means that person will keep on doing once he has been penalized. He'll do it with others.
It's like saying that if you have been challaned once, then you can jump as many red lights as you want to. Then that's not
absolutely right. I completely agree with you. I would have said that in the end, but now that you said, you've taken words from me. So basically, it is not a very good res judicata should not apply to competition matters because these markets are very sensitive. That means you are disturbing the equilibrium of the competition in the market.
Understood.
Why should CCI not penalize again? Rather, that should be considered as aggravated case. It should be considered aggravated factor and heavy penalty should be imposed.
It's like a repeat offender. It's like a repeat offender.
It's a repeat offender. It should have been like that only. But see, let me try to explain the legislature intention here is a repeated allegation under section 3 or section 4, which has already been decided in earlier case. So normally the jurisprudence so far grown on CCI is that they don't penalize again. I'll give the example of DLF. So DLF was in 2011 penalized with 700 crores, 670 crores. That's a huge amount. Now, several cases of filed against DLF after that also. It's not only Blair Association in Gurgaon which filed the case. They won the case, of course. Several trade associations filed the case, and the CCI said yes, they have abused dominance. They did not penalize them. No penalties were imposed. They were convicted under section 4, but penalties were not imposed. Right. Because CCI also has to see the industry concerned. You can't keep on penalizing a company because he's fine. He has done once. Lesson has been learned. So that is, I'm being the devil's advocate here. The point is that is the purpose of putting this section, because why even an inquiry? Why even an inquiry when we can't penalize? That is the point why this amendment has brought in, and this section 22 has been imposed. So I am basically on the borderline side, though I principally agree with you, but there is a reason for doing that also.
Sure.
Okay.
So let me proceed, as a time check, this is 1:14 by my watch. So I think if Although the Q&A has been, is being taken in between only. So if you could still
I
try
think
to
you
wrap up
now,
in the-
if you permit me to, because I have to say something in the end, you permit me to say
Yeah.
that. I think
So
people
overall,
he like to
Mr.
hear me.
Sharma, if you could try to wrap it in the next 10
I will
minutes.
wrap it faster. I'll be
Yes,
very fast now.
10
Let
minutes.
me be faster now. All
Yeah.
right. So I'll be very faster. I'll just stress on slide which are more important. So
Yeah.
this slide in the second area is DG has been in power to give supplemental, which already was there, but now the law has been codified. And there's a removal of ambiguity or gray areas on cases where CCI chooses to ignore finding. Now this last bullet is important. There are a number of cases. There are a number of cases where there was no provision in the act for the empowering the CCI to close a case where it did not agree with the DG. Let me explain the technicality here. So once a complaint is filed, CCI has to make a prima facie view whether they should intervene or not. Now, once they make a prima facie view, they refer it to DG. DG investigates. Now, DG report comes to the CCI. Now, DG report can two sides. It can either say there is a violation or it is no violation. In case of no violation, CCI will give the chance to the informant to come and file objections. But in cases where there is a violation found, but after the inquiry, after hearing the objections of the parties, CCI come to the point view that there actually no violation. So there was no provision in the act to close that case. Understand? So what CCI used to do was, it was very abnormal. CCI is like a court of law. DG is like an investigator. Imagine the charge sheet being filed. Charge sheet saying in the criminal jurisprudence, charge sheet says there is an evidence, there is a violation. This person has committed murder, for example, and the court not being empowered to exonerate the accused if it finds that there is no case made out. It was that kind of a situation in the Competition Act. So that situation has now been cleared, and the section 26(9) has been introduced that CCI can even close those cases. And interestingly, this was so gray area. There was no appeal possible under the against such orders. And CCI used to pass those within orders, so-called orders only. No section was mentioned because there was no section in the act. And there were very interesting Jindal Steel and Steel Authority. Jindal Steel and Steel Authority case, I don't have time, otherwise I would have told you. And the Concord case of Indian Railways, abuse of dominance. The very interesting Jyoti Swarup Arora case. So there were cases which were actually there at that time. We were party to these cases. That's why I'm telling you, this is a very gray area. So now the law actually, thankfully, have been taken care. And now this another important is abuse of dominance. Now penalties on abuse of dominance, this one should note, has been actually enhanced. And global turnover has been introduced. This is very, very, in my personal view, very humbly, I want to say, it's a retrograde step. Because this step, and please read the bullet, though there is no change in maximum percentage or turnover of income up to which the penalties can be imposed, it remains 10% or maximum 3 times the profit for each continuous of a cartel, whichever is higher. But the turnover or income has now been specified. Turnover means global turnover derived from all the products and services by a person or enterprise. Now, here I'd like to take 1 minute or 1 or 2 minutes. See, this is this is a very debatable issue in the competition law jurisprudence. Initially, they were imposing penalties on relevant turnover. Then came a judgment of Excel crop in Supreme Court. Supreme Court said no, it is absolutely nonsense. That how can you impose a turnover, a penalty on the whole turnover when it's a multi-product company? There could be MNCs. The cartel has taken place only in one product. The other products are not under cartel or not. There is no allegation of any anti-competitive behavior there. How can you impose penalty on the total revenue derived from all kind of products? So that thing was actually accepted by the Supreme Court, and Excel crop case in the Supreme Court said the turnover could only be on the relevant product on which the violation has been found. So that was known as relevant turnover, and this took place in sometime in 2017. So there was a lot of relief to the industry at that time. But now what has happened is surprisingly, I don't know how this happened. The act says, now it's not regulation, it's the act which says the global turnover, not only total global turnover because of MNCs. What will happen to the MNCs? What will happen to the big ticket, big digital tech companies? Just imagine. Google being penalized with global turnover, imagine. So the point is, just give an example, please don't get me wrong. Google is doing wonderful. We are so happy with Google. Without Google, we can't even function, in fact. So the point is, this concept of penalties actually on global turnover is also alien to the jurisprudence all over the world. Let me put it like this: that nowhere in the world, this kind of, to my knowledge, nowhere in the world this kind of concept of global turnover exists, because there are codified regulations in the European Union as well in the United States, which are the two hubs of antitrust. They are the mothers of antitrust, so to say. US is, of course, the mother of antitrust. So they have actually quite detailed guidelines that And that is actually degree of proportionality is taken care. So the penalty has to be proportionate to the offense committed. It cannot be disproportionate. But this global turnover actually is bringing it back, taking it backwards. So we have gone back to before 2017 now. And that's very unfortunate. I know why it has happened. I have no idea, because this has happened in the Lok Sabha, Rajya Sabha. It is not something which is recommended, to my knowledge, in the Parliamentary Standing Committee also. And now the next, because time, now this new concept of, and this, of course, I've said this slide, what I've said in this slide also. It is meant to nullify the import of the said judgment. This means enterprise found guilty will be to 10% of the global turnover against the principle of proportionality, well established in jurisprudence across the world. The slide is very, I've said what I wanted to say in this slide. Now we come to settlement and commitment with a new concept introduced.
Just 5-second question very quickly. So, but you said the global turnover will be clarified by the CCI in the regulations. So,
No. Where did I say that? I never said that.
I think I read it in the slide. Can you just go back?
No, sir, no.
Or maybe I misinterpreted. No, just scroll up. Yeah, here when you're saying turnover and income as may be specified by regulations by CCI, what does that mean?
Where is it written?
Explanation 1.
But expression 2, for the purpose of this clause, turnover means global turnover. So turnover has been considered to be global turnover. We have to see both the explanation together.
Okay. Explanation 2 is explaining the explanation 1 basically.
Yeah, so explanation 2 will supersede explanation 1. That's the problem.
Okay. Understand. Yeah, it's quite unfair. I agree with you.
I mean, maybe we're not thought about it because too early for us to actually understand that why it happened. I'll have to think about it more, but prima facie it appears to be little retrogressive step.
Understand. So, Mr. Sharma, 5 more minutes if you could wrap up.
Yeah, please. Let me run quickly. I just see the slide.
I will not ask any more questions, I promise. Yeah.
I'll just to run through the slide settlements.
Until you finish, yes. Yeah.
So settlements are mentioned. Settlements are basically to give comfort to the industry again.
Put it in the screen mode, Mr. Sharma, if you could put it in the screen mode.
Wait a minute. Yeah.
Yes.
So this concept of settlement and commitments have been again inserted on the recommendation of the industry, and it is in sync with the similar provision in the EU and USA and other advanced jurisdiction. It has been introduced after prolonged deliberation, on the demands of the industry to reduce unnecessary litigation in appellate tribunal in the Supreme Court, and important steps toward ease of doing business. This is actually a step toward ease of doing business. There's no doubt about it. What it means is that when there is a case where the CCI, after the DG report has come, investigation has taken place, there is ample evidence of the company having actually committed the violation, right? Why should it go through the inquiry? Why should it hire? I should put to the lawyers and continue facing the court of inquiry before the CCI and then get penalized when it knows in the heart of its heart that it is an indefensible case. Well, there's a case of a cartel which is absolutely clear. There are email exchange between the parties. There are tables given that what rate you should quote, what rate this company will quote, and they're absolutely clear. Evidence, direct evidence are there. Why should it go through that? But what the CCI has understood is, except for the case of cartels, so cartels are most pernicious. So cartels are excluded from this. So cartels cannot take the benefit of settlement. For them, the leniency is there. For them, the provision is to go to leniency. You have to go at the right time to the DG and to the CCI and say, yes, we are in a cartel. Please give us a penalty waiver. So then the penalty waiver is given up to 100%. That is a separate thing. But for non-cartel violations, that is section 3(4), vertical agreements or abuse of dominance, there is this window given now, and it is only after the receipt of the DG report, prior to the final order being passed under section 27 or 28. So CCI provides an opportunity to the party. Anyway, the DG can be summoned. DG can will be also listened what they have to say, whether they object to settlements or not, and then they reject the settlement. They accept the settlement. They'll propose certain monitoring mechanism for that. How it will be settlement will be monitored. How will they cure the market from the anti-competitive conduct which they have done, right? They will restore the competition into the market, and they will be monitored for some period of time. They'll give us terms and conditions of monitoring also, and monitors will be appointed also, and then they have to pay some sum. So it's like a penalty, which the penalty will have to be paid in advance to the commission. And the good part is that it's not appealable. So the other side cannot go and appeal. That, well, why have you settled? The settlement is not appealable. But the grace here is compensation can be still claimed. This was an issue of debate. In fact, I had also given this comment to the PSC that you should not let them go without compensation, right? So suppose I have committed a gross violation. I've abused my dominant position. I'm a monopoly, and I've finished the downstream market. I need no case, but I'll not take name. Grasim is the worst case when I'm on the side of the other side. So I'm saying so. Sorry for saying that, but the point is they have finished the downstream market spinners in the viscous staple fiber uh, product. So they are the monopoly. They are the only company in India which produce this product. So that being the case, why should they go scot free? Suppose the CCI, whatever reasons, enters into a settlement and a pitiable sum is being asked to be given, when the damage to the market is too much. What will happen? So those who are actually victims of that conduct must be given a right to claim compensation. Luckily, the parliament has seen that and this has been retained. This has been introduced. Now the commitment. In the commitment, what happens is that is a stage where before the DG report, where the CCI has taken only a prima facie view, but the companies feel that yes, we are wrong. So they want to sort of give a commitment that we will not continue with this anti-competitive conduct further. But the DG report has not, the investigation has not started. Or even if the investigation has started, the report has not come. So at that stage, you can go and give commitments to the CCI. Let me tell you, all the cases in the world, whether it is against Apple, Amazon, or against Google, they've all offered settlement and commitments in US. They never go through the entire process. They settle the case. They pay billions of dollars to the other side and they settle the cases. That's how it happens in US and America. All cases of big cases are settled. Whether it's the Google publisher case, e-publisher, e-book case, all those cases. So this thing saying now has come to India also, and it's a good development, I will say. But here there is here again it is not appealable, but there's no provision for a compensation here. But monitoring mechanism will be there. I think the slide is self-explanatory. I need not explain further. There's another section which says that the terms of settlement and commitment, if they're not honored, then the CCI may even revoke the or withdraw the pass the order and continue with the inquiry if they fail to comply with the order pass and or they have not come out with true disclosure. They may have hidden something. Material, then there is also the change of material facts. Then the CCI, apart from the penalty which will impose under an inquiry, after an inquiry, may impose a penalty up to legal cost of 1 crore also. The leniency regime. So the leniency regime, as I said, is applicable for cartels. And this leniency plus means that if you are being investigated for a cartel, for a particular product range, but you know that there is another product range where also we are in understanding with each other, we have cartelized, then you can immediately go to the CCI and say that we also want to disclose this. Then you will get the benefit of the priority market status. So that is leniency plus. It is on the line of the US, UK, Singapore, etc. It happens already there. So this has been again introduced on the. This will actually basically avoid the unnecessary harassment which takes place before the DG for investigation. People are called, their call detail records are collected from the service providers. CDRs are collected. CBI cases refers cases to CCI. So all kind of prosecutorial harassment is actually avoided. If you go to the CCI and say, yes, we are in a cartel, we know we have evidence, you got the evidence. Recently, downgrades have happened in some companies. You keep on reading that CCI did raid on a company and they take the hard disk and they found there is evidence. So people go and contact lawyers and they say file leniency. But there are cases where the people leniency are not filed. There's no evidence. So there comes the role of economists, or the forensic experts, where they say that whether it is required to be admitted or not. There may be nothing in the record. So those kinds of cases we all keep on dealing with on a day-to-day basis. So the point is leniency plus is another beneficial provision. Now I'll come to quickly the beneficial provision. Please go through it. So power of DG. Again, this is an issue which I'll take in the end. So DG power earlier the DG powers were as they existed in the Companies Act, apart from the similar powers of the CCI under section 36 of the Act. But now that has been codified and these powers have been specified. You can see this that they can require any other than even third parties can be summoned. Limited power of civil court basically are there of examining a person on oath, requiring discovery, production of documents, issuing commissions, etc. Those powers were with CCI, they were also with DG. But now those powers were with respect to the party concerned. But now people other than a party have also been asked, the DG has been empowered to call them. But what is controversial here is this, the third bullet, that they may examine any person who's an agent of the party, and in the agent, they've included legal advisors. Now, legal advisor, whether in-house legal advisor or even external counsels are covered. We don't know. Apparently, the Parliamentary Standing Committee's recommendation are very clear. It will not include the advocates, because there is a privilege client attorney privilege is there, which is protected even from civil courts. So what I communicate to my client is privilege under 126 of the Evidence Act. Even the courts of law cannot ask me what was the advice I gave, right? But here is a CCI. Can CCI be given that power? Can CCI be given power more than the court? We had given this specific suggestion to the Parliament Standing Committee, and the committee has actually accepted that also. But unfortunately, for whatever reason, the Parliament did not feel it proper to give that caveat that will not include external counsel. So it's a gray area. I'm sure it will be litigated. So this is, and similarly, making application was same. Earlier, the application for search and seizure for conducting a down raid could be only made by the DG with the approval of the chairman CCI. They have to go to CCI first and take the approval, then only they'll go to this. But now it has been made. Now, quickly, and I think I'll run through this. The point, one of the important point is pre-deposit 25% penalty. So when you file appeal against CCI orders, earlier the practice was that it used to be bargained that for how much percent is the penalty you will deposit, the stay will be granted or your appeal will be admitted by the NCLAT. So mostly the going rate was 10%. In most of our cases, 10% was granted, the stay was granted, or granted, the appeal was admitted. But now the CCI has, the Parliament has said pre-deposit 25%. So you have to deposit 25% of the penalty imposed. Only then your appeal will be heard by the NCLAT. This is a very important provision. And of course, decriminalizing some offences, compounding of offence power has been given to NCLAT, certain offences to independent directors, etc. That has been given. I think this I come to the end of the session, and I just draw attention of the viewers to the two important articles which I had written first after the Competition Amendment Bill of 2020. It came in Economic Times. You can see the date, 5th March 2020. And when the second amendment bill came after the Parliamentary Standing Committee report, then also I wrote an article cautioning the Parliamentary Standing Committee on certain aspects. So you can't read. So for your benefit, I've summed up what I've written in the article just for the. So I actually, this is a critical appraisal from my side as a competition activist, I would say. So in my first article, I basically dealt with the gaps in enforcement have not been completely removed. Section 4. You will be surprised, Sumit, to see there's not even a single mention of Section 4 on the entire Act. Competition Amendment Act doesn't talk about Section 4 at all, as if abuse of dominance was absolutely okay. There were gaps. There were gaps. Anti-competitive agreement is fine. Section 3 and Section 4 you have dealt with. But what about Section 4? So in my first article, I mentioned the case of e-commerce companies. So there is Uber, there is Ola, there is Amazon, there is Flipkart, right? All of them are big companies. All of them are doing wrong things. They are doing deep discounting, for example, or they are doing preferential selling. They are doing surge in rankings. What will happen to them? Because they will never be dominant, but they are doing conduct which is anti-competitive. So what the law as such today states is a form-based approach. Under Section 4, there are 5 limbs of Section 4, which says you will not do this, 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 this. If you are dominant, it will be deemed to be abuse of dominance, right? So it's a per se approach. Again, it's an effect-based approach. We as experts have spoken at length, have written articles and done so much to the Competition Law Review Committee, even to the Parliament, the Standing Committee. Please do something on this. It's a farm-based approach should be done away with. Even in the Google case, let me tell you recently, and it is in my blog, the NCLAT, while dismissing the appeal of Google, recently, it's a very recent judgment, of 29th March, let me just see. Yeah, 30th of March, this order of NCLAT 30th March says that they agreed with Google that effect-based approach should be applied. That means you must show that your conduct has resulted into effect on competition. This was the defense of Google, that whatever I'm doing, where is the effect on competition? But say no, because Google admitted you are dominant, and that they cannot deny. Google is Google. Just because they were dominant, they were penalized. So this is the first biggest issue which, and that's why I suggested in my article, like US got a provision to attempt to monopolize. So if Amazon or these big giants, they do something which is Uber, for example, if it is finished in the taxi market, if it is actually doing so, why should it not be inquired? Why should it not be investigated? Under Section 4, it's attempt to monopolize the market. You understand? When you're doing a conduct which is apparently anti-competitive, you cannot, under the present law, be penalized, or you cannot even be investigated by the CCI because there is no law to that effect. So called form-based approach against effect-based approach. That is the first bullet which I said in the first article. And the second article, when the second bill came, I found that also was missing. In the 22 bill also, the form-based approach was not touched. Section 4 was left as it is, as if there's everything hanging dowry. And the another point where I'd like to mention is there is no, mention about IPR. For example, intellectual property rights and abuse of dominance. So if you are a patent holder, right, and you misuse that patent for some reason or the other, you cannot be, you can be prosecuted under Section 4, abuse of dominance. Under Section 3, you cannot be, because there is a exemption carved out for Section 3(5) for all IPRs. It cannot be anti-competitive agreement between a patent holder and its licensees because they have a benefit of Section 3(5). But what about Section 4? I'll give you the very excellent example of, if you may have heard of Bayer case. Bayer was compulsory licensing. Bayer was selling a drug which was 2.8 lakh, maybe my figures are not correct, 1.8 lakh dose for cancer drug. Dexavar produced the same drug at 8,800 rupees after it got a compulsory license on public interest by the patent board. Matter went to Supreme Court. Supreme Court dismissed the claim of Bayer. Yes, it is in public interest. You can be asked to give license to your patent, compulsory licensing. That was under the Section 85 of the Patent Act. You know what happened? United States of America, after the decision, put India under Super 301 watch list. Even today, we are under Super 301 watch list. All our IPR regimes are looked with suspicion by these big countries because we use the compulsory licensing from the IPR laws. But what if Section 4 is invoked by CCI today? They can do it. Well, unlike Section 85 of the Patent Act, where there's a cooling period, 3 years. There's no cooling period in the Section 4. So if you're an IPR holder, you can easily I can drag you to the CCI. I can say, look, what you're doing is unfair pricing. Well, Section 4A talks of unfair pricing. So if a price is unfair or excessive, then you can be certainly summed up. Can it happen? It can happen. It's a gray area. So similarly, I also, in the second article, I talked about I was critical of material influence, a test of control, which could lead to gun jumping, and even structural issues, because I was a part of CCI at the time when CCI was being made. CCI enforcement had not started. We were there for 2.5 years. Mr. Vinod Dhal was a member of CCI, sole member. So we said CCI should not become MRTV Part 2. Why? Because there was no functional autonomy. CCI should be functionally autonomous. So for that, you need financial autonomy. So I gave the specific suggestion to the standing committee that please do something about financial autonomy of the commission. They have no source of revenue like this SEBI, separate except for the fees which they derive from the regulation filing, which of course is quite high now. And the second point was lack of judicial member. The Mahindra judgment of Delhi High Court has said that CCI without a judge, the judicial member, is not a proper quorum. You cannot adjudicate on highly technical legal issues which affect industry at large, and it affects economy without the judge being there, right? They actually scrapped that judgment, but there's no clarity. And then last but not the least, no clarity on DG. Just explain whether legal advisor will include external counsels or not. This point I also touched in the second article. And as an activist, Sumit, I must confess that I have written wherever I get a chance. I've even approached the finance minister wherever, if I could get the time. I approached Mr. Jen Sinha personally. I gave him the suggestions in writing. They were considered, they actually accepted, but unfortunately in the bill or in the act, they have not been. This suggestion has not been accepted. The last one, legal advice as well.
No, Mr.
With this, I stop. I think with
your,
this, I stop.
Your passion and your activism and your knowledge is flowing through the webinar. I think we all can sense it. We all can feel it. I'm sure you can go on, and you can speak about your experiences of several cases. But of course, time is a limitation, and we will keep finding more opportunities for you to come and speak and to the August gathering. So, Mr. Sharma, we have a few Q&A. Very quickly, we will wrap up in the next 4 or 5 minutes. Request everyone to be patient. Mr. Sharma, if you could unshare the screen for a while.
Before I unshare, I just like to show this blog of mine, which is one of the oldest blog in the country on competition issues. It's called Antitrust and Competition Law blog. So if you Google competition laws in India, this blog comes on the top automatically. It has been running since 2015. I was the first lawyer to start this blog. People are requested to welcome to read this blog. You will find the latest updates on competition issues in this blog. Thank you very much.
Amazing. Thank you, Mr. Sharma. And requesting my team, Mr. Sharma, if you could unshare the screen. Yeah. So requesting my team to share one video. We'd like to share one small 1-minute video about Complinity with you, and then we'll take 3-4 important good questions and wrap up in next 5 minutes. So team, please.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances. All in an integrated platform that is easy to use with automated alerts and risk management capabilities. Is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management, request a demo at complinity.com. Welcome to Complinity Technology.
Yeah, thank you. So with this, we are almost at the end of the poll. Allow me a second. There's a small poll that I would like to launch on Complinity. Anyone who's interested to take a demo of Complinity compliance software, you could please indicate your preference, and then my team will sort of reach out. Very quickly, if you could just indicate your preference. So while you are filling in next 10 seconds, Complinity is, as you saw in the video, is a compliance software having 2,000 plus laws and 25,000 plus compliances. And under all the laws, including competition law. Although competition law, there are less compliances and more as it's an economic legislation. But yes, it does cover competition law. Otherwise, income tax, GST, labor laws, and industry-specific laws of over 50 plus industry verticals are there. Okay, anyways, as you are filling up this poll, let me move on to the Q&A any which ways. So, Mr. Sharma, if you could switch on your video, come back, and just 2 or 3 very, very important questions.
Sure.
Sayam asked that the 2012 amendment bill sought to amend Section 4 to incorporate the concept of collective dominance. The 2023 amendment bill, as recommended by CLRC, did not amend Section 4. What are your views? So, yeah, I think you touched upon that Section 4 of abuse of dominant position has not been amended. And anything to add here?
I will add here. See, collective dominance is a concept which is again alien to in Indian competition law, because collective dominance concept exists in Europe and USA. And in India, we don't have that concept. This was also debated in the Competition Law Review Committee, but it was actually felt that collective dominance will be difficult to be, sort of investigated, etc. So this was not agreed. But this 2020 bill also did not, by the way, did not mention collective dominance.
Right.
I've already said Section 4 is the only area, and it's the worst. See, I just add one sentence here. Why competition law exists? The purpose of competition law is to prevent exercise of market power, prevent abuse of market power. That means abuse of dominance is the purpose. All other are ancillary things. Because either you will cartelize. If you cartelize, you will behave like a monopoly. If all of you come together, you become like a big person, right? You'll do whatever you want. But if you're a monopoly already, you'll do whatever you want. My choice or high, that kind of word which somebody uses. So that kind of thing should not happen in the market. No? There should be perfect competition, balance should be there. So Section 4 should have been touched. There was specific suggestion given by the stakeholders to that effect.
Okay, very interesting question asked by an anonymous attendee, that what if today CCI comes to know about an anti-competitive agreement which was executed 5 years back, but was not it didn't come into the public domain, or nobody came to know about it. So just will this 3-year limitation apply to CCI also, to take cognizance of a 5-year-old matter?
That is the point which I said. You're right. Today it will be difficult because the act has been amended. Today they cannot. But if it's a going investigation and there they discover, they can go back.
But is 3 years for filing a complaint, or even for suo motu taking cognizance by CCI also?
Let me see this section once again.
It's a very, very interesting question, I must admit.
Yeah, no, it's an interesting question. I agree.
Yeah. And also, can the delay beyond 3 years be condoned by CCI?
Yeah, delay can be condoned. I think that I'm sorry, I omitted to mention that the delay can be condoned. Right. That's a fact. So they can actually entertain that old case also, provided there are reasons given by the informant of not coming earlier, why they could not come earlier. And there are genuine reasons given. So you are right. The delay can be condoned, provided that an information or a reference may be entertained after the period specified in the first proviso, if the Commission is satisfied that there had been sufficient cause for not filing the information or reference within such period after recording reasons condoning such delay. So basically, in the public interest, I'm sure cases of cartel can be investigated, will continue to be investigated even if they are old.
Right.
Is my view.
Right. I think I also subscribe to that view, because if they can condone the delay for filing the reference, they can, of course, if it's a PI, a public interest thing, they can, of course, take cognizance of old matters.
Yeah, even normal information also.
Right.
From anybody.
This 25% is my question. 25% pre-deposit penalty. It is in line with the income tax also when we have to appeal to IT, AT, etc. 25%. So, but with the penalties in competition running into hundreds of crores, 500 crore, 1,000 crore, is it fair? Is it fair to have a pre-deposit of 25%? Isn't it against the ends of justice, to get the final disposal? Isn't it really anti?
As I said,
is it anti-justice or anti-judicial? I would say to that extent.
No. It's not anti-judicial, anti-justice, but it is anti-industry for that matter. Yes, it is anti-industry. Industry will definitely be hurt. Or it is hurt. See, what happened is that if there is a big case, suppose Google, now which all lawyer will not be there with Google? You name him, from Hari Salve to whatever big names of the senior advocates. Their fees runs into millions. That apart, there they bargain. By seeing the face of the lawyer with 10% kara dijiye, 5% kara dijiye, things like that. So this NCLT had a wide, discretion. So that, with due respect, was not fair. Because किसी केस में आपने 10% कर दिया, किसी में 5% कर, why? Judge is a judge.
Right.
Who's going to ask him? So to avoid that kind of discussion, perhaps this is my personal view, to avoid giving that discretion to the judges or to the judiciary, which again, my view is this is against the judicial, sovereignty. It should not have been done. The judges should have the discretion. Having been a judge myself for some time, I remember that we should have this thing. But again, the government felt that because there will not be a check and balance, because everybody will go and appeal then. Actually, it's also to reduce the appeals. No, if suppose when you are providing commitment on one hand, settlement on one hand, even leniency for one hand, why should you go to appeal? Why should you collect the appellate court? If you agree in your heart of heart that you've done a mistake, fine, forget it. Pay the penalty and go. Simple.
Yeah. Okay. One last question from Mr. Somu. He says that has the competition amendment bill really impacted the ease of doing business in India?
No, it has. As I said, I personally feel that it has actually brought in the ease of doing business. This is my article of 2022. If you see, it is actually towards ease of doing business only, because most of the facilities have been given for combination. Green channel have been codified. Period reduced from 210 days to 150 days. Even prima facie view can be taken 15 days. Earlier it was 30 days. So all those which I said by bullet in my slide, if you see, they are all towards ease of doing business. Similarly, the settlement and commitment also promote ease of doing business for the industry. Suppose you are unfortunately happen to be caught, why not? You should settle the case with the CCI. So these are all. So basically, out of the 4 limbs, if I can say, the maximum what the Act has done is to make it business friendly. They have not been able to remove the gaps of enforcement. This is my view. Gaps still remain, as I said, IPR versus abuse of dominance. Then abuse of dominance itself, there are gaps. Effect based or form based. This is a big gap. The gaps are still remaining, but yes, they made it ease of business friendly. That much I'm sure.
And even that 30-day, the 30-day removal of the 30-day timeline, because of which penalties were, being imposed.
Conjumping. Yeah, that's what the same thing. So many of these issues are now a part of law. It is no more with the regulation of the CCI. They are part of the Act. That is definitely industry should be happy about it.
Right.
Why not?
I think with that, Mr. Sharma, you and I are the only 2 people standing in the way of lunch and the audience. So thank you, audience. Thank you, everyone, for attending this webinar and making it a successful webinar in huge numbers. And thank you, Mr. Sharma, for sharing your knowledge and experience and enthusiasm that was coming out all through the webinar. And thank you, my team, for organizing this and putting this together and coordinating the entire piece. So thank you, everyone. This is part of Complinity's Compliance Wire initiative, where we keep bringing good experts on interesting and relevant topics. And by the way, Complinity, in association with Vaish Advocates, is one of the first organizations now to hold this webinar, after the Competition Amendment Act. So this is the first webinar, to my knowledge, happening on the Competition Amendment Act within within 10 days of the act being notified or receiving the president assent. So thank you, Mr. Sharma, for your assent to come and chair this session. And thank you, everyone. We'll come back with more such interesting compliance series next month and going forward. Thank you. Thank you, everyone. Bye.
Thank you, Sumit, and thank you, everybody. Thank you very much.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances, all in an integrated platform that is easy to use with automated alerts and risk management capabilities, is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.